overview of what introducing the IT planning for our school. Dean Parrish will be doing that for short remarks. We'll kind of address the issue of why pro bono patents and why that makes sense, and some solutions to some of the problems that we've touched on as far as that's concerned. And then kind of an introduction to PatentConnect Launch. You guys have heard a little bit about that so far, but we'll kind of delve into the details on that. And then Mark and I, we've kind of gone throughout the city and state on this. What exactly is a pro bono? So we'll kind of go through part of that and kind of why should patent attorneys think about participating in pro bono. And we'll have a little discussion after that. And then after that, Jason Mont, who along with Jeff and Kai has spent an incredible amount of time this summer with a very, very nice website for PatentConnect Launch, which is unlike anything across the country. We're very proud of it, and you'll see why here. So with that, Dean Parrish, you mind giving some introduction?
Well, thanks so much. This is a special time for the law school. There's been a lot of work going into this project for the last couple of years, and so as a dean, I'm incredibly proud that we're launching it now. I think I want to dispel one myth. Most faculty at the law school are pretty happy people, so all this grouchiness, this is just for one day. I thought I'd just make three quick observations from my perspective as a dean. One, experiential education, the ability to give students opportunities to dig in and work with live clients while they're in law school and get a little bit of experience before they graduate is so critical these days. No top law school is not considering how to connect high theory and doctrinal knowledge with understanding how lawyers actually practice. And the Intellectual Property Law Clinic is one way that the law school provides this opportunity for our students, and frankly a non-traditional public interest area. So I'm incredibly pleased for that because it fulfills one of our missions, along with our other 5 clinics and 6 other projects, of providing students hands-on experience while they're in the law school. The second part is the IP clinic and the Patent Hub is part of a much broader vision that Professor Janis started 5 years ago to really launch a center on intellectual property that was at the forefront. Sorry guys, I was speaking too quietly. Is this better? At the center of intellectual property law. And so it has a particular vision. That vision is the idea of intensive practical training for our students connected with high-end scholarship that is really advancing knowledge in the IP area. There's some intellectual property centers from other well-known schools that have been out there a lot longer and have more resources. I don't think any of them are quite creating the particular blend of practical skills experience, outreach to the community, and high-end research and scholarship that we're doing here at IU. That's a credit to Mark and Norm and Don and others that are involved in the center. And it really means that Indiana and IU and our School of Law is at the very forefront of what's happening in intellectual property training among all law schools in the country. Last year, we were ranked 20th in the nation for the IP program, and frankly, I think that understates the way how significant the program is. So I'm excited about that. The third thing is I think there's a little bit of a myth among, at least among some of the popular commentary about law schools. The law schools are just not connected with the bench and bar and out of touch with what's really happening. And maybe that's true at certain places. It's certainly not true here in Indiana. And I think the IP Clinic and the Patent Hub just really underscores how to make those strong connections between an education institution, government entities, private practitioners, to really have an impact on the ground. And so I know Mark and Don and Norm have been reaching out to patent prosecutors and litigators and the whole patent bar throughout the state. The fact that IU is working with Purdue itself is a thing I think there's more Purdue people here than there is anywhere else, designed particularly there by Mark. Outreach to innovators and entrepreneurs as a real way to make a difference to people's lives in the innovation economy here in Indiana. And that also makes me particularly proud as a dean, because I think sometimes people forget the missions of the law schools. It's not only to educate the next generation of lawyers and leaders, which is incredibly important. It's not only to have an impact in advancing knowledge in a way that makes a difference on how we understand some of the thorniest, most complicated legal issues of the day, but it's also have an impact in our communities and in our state to make better lives for people and a stronger economy. And so I'm really grateful that Mark and Norm and others have come together to really hit all three of those notes, providing a really exceptional experience for our students, reaching out and getting connections with the U.S. government, patent bar here in Indiana, and making a difference in the economy here in the state. Thank you so much. Hopefully that was more time than I was permitted. I didn't get the bell, unlike Mark, so I feel good. Thanks again to Lily and everybody else for hosting us today.
Thank you, Barry. So with that, I will give a little introduction here to the panel. You guys have already met Professor Janice. He's a 1986 grad from Purdue University with a chemical engineering degree. He's currently the director of the Center for Functional Property Research at the Maurer School of Law. Next to Professor Janice is Jessica Van Dalen. She also is a graduate of Purdue University with a graduate degree in material science engineering and a 2010 graduate of the Maurer School of Law, and she's an associate at Baker Daniels. And then next to Jessica is Jason Mont. He has his degree in chemical engineering from Indiana University, and he also is a Microsoft fellow in the Center for Functional Property Research, and graduated from the Chicago Law School as well. So with that, I'll allow you guys to call you a little more introduction to kind of your connection to the pro bono scene in the state a little later on. But with that, we'll kind of go through my part of the presentation here. You know, why are we concerned about pro bono in the patent arena? One is it's a classic chicken and egg problem that people run into. I was always very frustrated in private practice when I would come across an entrepreneur, an individual who was very excited about the idea that they came up with. They wanted to create a business around it, only to be thwarted by the a quota of $10,000 or more to protect their idea. And without that protection, it was very difficult for them to go out and get funding. So if you don't have funding to protect your idea, you can't go out and get funding to create a business. So to me, it's a classic chicken and egg problem that by providing pro bono services in the area of patent law, you allow people of limited means, such as the patent office, really resource individuals and groups to go ahead and protect their idea so that they can go out and protect their core technology and then turn around and get some funding to do that, to kind of launch their endeavor. But without it, it's very, very difficult to do so. And also, and I've seen this with at least one of the clients that the clinic has served, that early on, they just did not have the financial means to do the proper due diligence to check into their IP. And right now, they're potentially facing a pretty significant issue, which could implode their business. So they've got years and years worth of time and resources invested in something, only to find out that they potentially have some issues here. And that's why I'll tell you the reason they didn't do it is because they didn't have the resources to do it, and it could be very problematic for them on a going forward basis. So pro bono in patents is kind of unconventional. I think we're all kind of familiar with some of the more social justice aspects of pro bono that we've had. But because people are unable to afford to protect their rights are being lost. And patent law is one of the very interesting areas of the law where the rights are spelled out in the Constitution itself, where it tells, you guys are all familiar with Article 1, Section 8, where the founding fathers of the Constitution instructed Congress to set up a framework to protect the inventions. And those inventions aren't being protected. So we've got people that have rights that are unable to protect those rights because they can't afford to. So you've got people out there and businesses that are losing out on their ability to protect themselves and the rights that are guaranteed to them under the Constitution. What's been Congress's response to this problem? In the AIA, there was a concern that the AIA itself was kind of slanted towards large companies and people with resources, because those are the type of people that would be able to take advantage of the first to file system. Unlike the old first to invent system, where perhaps a small business that didn't quite have the resources to file a patent application could wait a little while because they rely on their first to invent status. Well, AIA changed that. It's now a rush to the patent office. Whoever gets there first wins. So Congress decided to take on this challenge for small and resource individuals. And they did that in the AIA section 22, where it outlines that the director shall work with and support intellectual property law associations to assist those that are financially under-resourced, and they're both inventors and small businesses, So Congress itself recognized the problem that the AIA was perceived to create, and they've set up a pro bono program to do that. So what has been the executive branch response? President Obama has had a couple of proclamations where setting forth what the Patent Office is to do to correct this problem. And the Patent Hub is a direct result of one of those executive orders that came out not only in February 2014, but before that as well, where the President authorized the Patent Office to go out and dedicate resources to assist inventors through accurate legal representations. And the Patent Hub that we're going to talk about here later on has 18 regional patent hubs out there that are covering all 50 states now. That's a direct response to the executive branch's efforts to develop pro bono services. So what are some of the solutions to this chicken and the egg problem? As Dean Parrish mentioned, the Maurer School has a pro bono IP clinic. We believe ours is unique in several aspects, but there are other IP clinics out there. And the USPTO has also recognized the problem, and one effort of theirs is to introduce the microentity status that gives microentities a 75% discount. They did that, and they recognized that, you know what, that's not enough to help some of these small inventors and small businesses, because they recognize that the government fees are a very small portion of the overall expense of filing and prosecuting a patent application. And they recognize that the attorney time and legal fees were by far a much bigger hurdle to filing applications and prosecuting them. So the Patent Office went out and they created a certification program where they went out and invited the IP clinics across the country to receive some certification, kind of a blessing on the Patent Office part of these various clinics and their abilities to service clients. Right now there are 23 certified patent clinics across the country, and the certifications are not just limited to patents, they're also trademark certifications as well. I believe the Maurer School is one of about 17 schools across the country that's certified in both of those. And now, more recently, the Patent Office, as I've mentioned, has started to create these regional patent hubs. I think the Patent Office realizes that the IP clinics only have a certain capacity to handle clients. As Dean Parrish mentioned, our goal in the clinic is not only to service those with lesser means, but it's also an effort to educate students so that coming out of law school they have some practical skills. Well, that takes time, mentoring people. So the throughput of the clinics is not probably what the private practice is able to provide. So there's a capacity issue there for servicing these folks. And so as a result of that, they've gone out and created these hubs where various entities, maybe it's lawyers for the arts type organization, bar association, in our case, it's the law school, goes out and creates a matchmaking service so that private practitioners can participate in providing pro bono patent experiences. And that's where law firms come into play, is that most of our service providers in this network are law firm patent attorneys, but that's not to leave out the in-house folks. We'll talk about that in a little bit as well. So what exactly is PatentConnect for Hoosiers? The Patent Office put it very succinctly. PatentConnect, or these patent hubs, and PatentConnect for Hoosiers, that's our patent hub, is basically a matchmaker, where we sit there and we take people in our system that are looking for pro bono patent services. We screen them. We look to our network of attorneys that have volunteered to provide the service, and we match them up. We try to do things like screen for potential conflicts. We try not to overwhelm our volunteer attorneys. We try to make sure that the pro bono folks that are asking for services have done more than just come up with a concept. Perhaps there's going to be a business plan requirement. But so we've done a fair amount of screening, recognizing that our volunteer attorney's time is very valuable, and we don't want to waste your time with clients that their idea may not have a good chance of turning into a fruitful enterprise. So again, the matchmaking considerations, and Jason will touch on some of these later on in his presentation as well. But we're very sensitive to people's workloads. If you only want to take one case on a year, we'll only give you one case a year. If you want two, we'll take you two. If you want more than that, we'll give you more than that. But we want to make this as painless and as rewarding experience as possible. Technical expertise. I'm a mechanical engineer. I have absolutely no business doing a chemical project. We're going to screen for that so that you're not getting matched up with something that doesn't make sense for what your technical expertise is. Conflicts. Everybody's got them. It's a big problem, particularly the larger your firm gets, and we want to help you avoid them. So if you have a particular client that's in one technology area, we're going to try not to send you clients that isn't that technology area because it's a waste of your time. Because we know you're going to run a conflicts check and it's going to get tossed back to us anyway. So we're going to try to avoid that. Again, we want to make the experience of rewarding. So here's kind of the process. All right. Who recognizes this guy? Who recognizes why he's on there? Very good. That's Calvin's dad. I don't know what his name is, but he is a patent attorney. So these guys at the bottom here kind of represent our network of patent attorneys. And I wanted to point out that the IP clinic itself is essentially one of the service providers. The PatentConnect from Hoosiers is separate from the clinic itself, but we're one of the service providers. So the way this would work, you got an inventor, comes up with an idea, they log on to the website, and based on their input, we pick one of the people on our network. We reach out to the attorney. The attorney gets back to us and says, yes, this is a match I'm willing to take, and then we step out of the picture. Patent Hub is no longer involved. Now you've got a direct client-attorney relationship. Somebody else comes up with an idea. Comes to the hub. Reaches out to the attorney. Attorney says, sorry, Norm. I'm really busy right now. That connection is broken. So we move on to the next attorney, which in this situation happens to be the hub. Seems like a good fit, a good match. Connection is made, and the hub itself steps out. The Patent Hub is a service provided by the Center for Intellectual Property Research. Again, it's not the clinic itself that provides this service. It's something that Casey will be running in conjunction with Professor Janice and Allison and myself to a limited extent. It's right now has seed funding from the Patent Office. This is something they're trying to get up and running. Again, there are 18 of these hubs across the country that they provide seed funding for. The School of Law is providing some, and most importantly, we've got other sponsors that are coming into play because, again, the Patent Office is providing some seed funding to get this up and running with the expectation that in the long haul, the Patent Office's funding will step out and these will be self-supported. So why in the state of Indiana would a patent attorney want to provide pro bono patent services? Well, one, because the rules of professional conduct state that you should be providing these services. And it's a responsibility of providing professional services at no fee to people of limited means. There is no mandatory pro bono requirement under the Indiana rules of professional conduct, but the rules do clearly indicate that it is a responsibility of attorneys to do so. Why patent law? Well, I was providing patents, a qualification for providing pro bono services or housing pro bono services. The rule states that it's the basic responsibility of each lawyer to provide public interest legal services in the following areas. One of those is the administration of justice. It's our position, clearly it's the Patent Office's position, that one way of administering justice is helping those who have rights out there that are being lost because they can't afford to provide these services. So we think it's a misplacement of justice, or people are being misserved because they can't protect their rights just because they can't afford it. So we're looking to you, Patent Bar, to help these people not lose out on these rights to do so. Another comment from the rules from the Indiana State Bar Association stated that all lawyers have an ethical and social obligation to provide uncompensated services with an aspirational goal of about 50 hours a year. Last I checked, how long does it take to prepare a patent application? You want to put a guess out there? Roughly 40, 50 hours. So for patent attorneys to satisfy this obligation, you're probably talking about a patent application or so a year to do this. So I encourage you to do so and fulfill that obligation stated in the rules. What exactly is administration of justice? Well, it's to increase the availability of legal representation to to improve the administration of justice. And it's not only to individuals, but it's also to groups. Throughout our visits with some people in some places, people thought that providing pro bono services kind of was limited to individuals. But clearly this rule states that it's also focused on groups as well. And as shown in the earlier slide, the patent office is of the opinion that it's actually the statute itself is of the opinion that it's the inventors and groups as well. So that's just kind of emphasize that this is not just a representative individuals and inventors. One last slide here on the rule is that it also spells out that the rules contemplate that in order to facilitate providing pro bono services, it's anticipated that government entities will be established to facilitate those. We consider not only the clinic itself, but the patent as an arm of the law school, which is an arm of the state, to be such a government agency. And the rules also point out that every lawyer should support these efforts to meet these legal services. And one way to provide that support is obviously to provide some pro bono legal services through the Again, why should you participate outside of your obligation or responsibility to provide pro bono legal services? I don't know about you, but during my private practice as a patent attorney, I wasn't exactly rushing out to provide guardian ad litem services or helping people in landlord-tenant law, those sorts of things that are more classic pro bono work, because I'm not trained in those areas. I'm uncomfortable practicing in those areas. So by providing pro bono patent services, it allows you to provide pro bono services in your area of expertise. And who knows, some of the people that you provide pro bono services to now will ultimately turn into paying clients. Obviously, that probably shouldn't be your goal from the get-go, is to pick and choose these clients just because of their ability to turn into potential fee-paying clients in the future, but it can happen. That's our goal. We want these entrepreneurs to be very successful, to create jobs, and to support patent attorneys and other professionals across the state. Another way to do it is it's an excellent networking opportunity. We've already seen in the clinic, there's been a project for 3 semesters. We're already seeing that clinic clients are starting to refer people to us by word of mouth. It's going to happen with you. It's already happened with some of our adjuncts that are helping with the clinic, but they're getting referrals from clinic clients. So it's an excellent networking opportunity as well. And the Lieutenant Governor also touched on this. This is kind of one of the missing links in the state, on creating an entrepreneurial ecosystem, facilitate some of these startups and these entrepreneurial businesses in getting up and running. So the more jobs there are in the state, the more high-tech jobs there are in the state, the more reasons there are to hire patent attorneys. So, in-house participation. This is a work in progress, but we know it can happen. We know that Lilly itself has a committee on pro bono where they reach out into the community and provide pro bono services. Right now, it's not in the patent sense, but they have other relationships with firms to facilitate that, and they're investigating those opportunities as well. So just because you're in-house counsel don't necessarily mean you're up for those. There's no opportunity there for you. We're looking for avenues to facilitate that. And Professor Janice and I are very creative people, so we will find a way to get that done. So with that, I encourage you at some point in time to visit www.patentconnect.org. Jason will be touching on some of the details here shortly. But with that, I'm going to start asking some questions to the panel here. So, Professor Janice, throughout our couple of trips here across the state here, particularly in Indianapolis, what would you say the results of our conversations have been in trying to recruit attorneys to participate in the network and have it been fruitful?
Thanks for asking, Norm. We're very proud, very pleased with the response. We know you're all busy, and we know we're asking you to take on more maybe than you otherwise would. But I think the key is going to be for us to be really partnering with you in a meaningful way rather than just saying, oh, we have these potential pro bono clients, we'll just sort of throw them at you and you'll never hear from us again. So what I liked best about those meetings was the exchange that we started and that we've continued, and we know many of you already. But I expect a lot of future conversations about how can we best do this, how can we shape this patent hub so that in fact it's a reasonable business development tool for you, in addition to a way to make it easy for you to engage in meaningful pro bono services. And I think that message is getting across. So we've got it, you've got the exact number, but you know, we've had, thankfully, a lot of lawyers already saying, yeah, sign me up, and you know, let me know how to register. And we want to make sure that we get around to everybody and that everybody has a chance to sign up for this. So very positive response so far. Thank you for those that we've already talked to.
Great. And following up on those conversations we have you found the rules of professional responsibility to be help or hindrance, and in particular Rule 6.7?
Yeah, both, all right. So we ran into questions about both what the meaning of pro bono ought to be to a patent lawyer in Indiana, and I think Norm has touched on that. And we also ran into questions about the distinction between pro bono and reportable pro bono as it's embodied in 6.7. And that maybe is another kind of a work in progress, but there are a couple of things that we learned that we thought were important. One thing was that virtually nobody we talked to with expertise suggested that the reportable pro bono requirement is a major step on the way to a mandatory pro bono obligation. No one, maybe someone is thinking in those terms, that we can't find experts who are saying, oh yeah, that's where all this is going, all right? I think that's very important. The second thing, and more of a technical comment, I guess, what we were told was that Rule 6.7 and the whole idea of a reportable pro bono requirement was an effort to get data on representation, particularly traditional pro bono representation of under-resourced individuals. They wanted data on that in order to assess where we were, and that might lead to further discussions about what the shape of the pro bono requirement ought to be. That should not be confused with the definition of what constitutes pro bono activity. That's Rule 6.7, what's reportable, is much narrower than Rule 6.1 explaining what pro bono activity is. And that's even spelled out in 6.7. I've got the subsection up here, but it says explicitly this isn't meant to displace the broader definition of what constitutes pro bono in 6.1. So the bottom line for us is that if you're doing representation of a startup company through the patent hub, if you're doing representation of an individual through the patent hub, but as far as we can tell, both of those things count as pro bono for purposes of 6.1. They might or might not be reportable pro bono under 6.7.
Great, thank you. Jessica, you've been working with the clinic now for about 3 academic years. What kind of services have you kind of seen the clinic provide as far as IP services?
A whole variety. Anything that our paying clients need services for, the pro bono clients do too. So on the patent prosecution side, it's anything from patentability and freedom to operate studies, preparing applications, responding to office actions. We've looked at IP agreements. I'm not currently involved, but Brad Maurer is, and they do trademark and copyright work at the clinic. We don't have currently any litigation going on, but I don't think that the clinic has any hard and fast rule against any sort of litigation project, especially maybe early litigation. And really the only kind of unwritten rule that we've put into place is that we won't, typically don't take on foreign prosecution, anything past a PCT phase, since that's expensive, and if you can afford that, then perhaps you're outside of the definition of pro bono. But really, it runs the whole gamut, and there's opportunities for anyone in IP to get involved.
And we should say, just to be clear too, that's, maybe you're about to say this, the scope of the patent hub is strictly directed toward patent prosecution pro bono work. The scope of the clinic is much broader than that. Maybe what you're about.
That's correct, Mark. Yeah, the hub itself is patent prosecution, and is Jason will touch on here, you define the scope of your representation in that front. If you just want to start out doing a patent search for the client, you can make that the scope of your representation. If you want to take it beyond that to a filing application, that can be the scope. Maybe you want to limit it to a provisional application, that can be the scope of your participation. But the scope of the representation is totally up to the attorney that's volunteering for that. Professor Janice, in line with Jessica's comments regarding the services that are being provided by the clinic, are those the types of services that you envision would be provided by the clinic in the clinical project?
They are. I mean, it's gone beyond our early dreams, I suppose, in some ways. But it seemed to us that the key focus to begin with was patent prosecution services, and that's where we started. We also found a lot of small businesses with trademark problems, not surprisingly, and so that was a little bit of an expansion as well. What I see is a trajectory where I would like to see this clinic expand in its capacity to take on patent work across a range of technical disciplines. That's really important. And I'd also like to see us expanding into IP and maybe closely related work for artists and other creative individuals, because we see that in Bloomington, of course, we see that all the time, the big need for that. And that would require us to expand the staff that we have at our clinic and expand our methodologies, but that's sort of what we're interested in doing, right? We think the need is out there, so that's where we see it going.
Great. As a follow-up to that, what types of clients did you envision the clinic serving when you came up with the idea?
Well, I hope that we would have, that we would be able to work with a lot of organizations that already were serving entrepreneurs in the state. And of course, I also expected that we would just attract clients from here and there, just like we used to call it elevator trade, just like, you get a phone call. So Purdue Foundry is one of those organizations, IURTC, Indiana Small Business Development Centers, Crane. Those are all organizations that already are out there facilitating entrepreneurial activity, and it's really incredible for us to be able to partner with them and try to provide the missing link that the Lieutenant Governor is talking about.
Jessica, your work with the clinic has these types of clients that Professor Janice has spoken of. Has that been your experience in the actual applications that are coming into?
Yes, all the organizations that Professor Janice mentioned have really, been excited to partner with the clinic and utilize the resources. So we've definitely had startup entrepreneurs from Purdue. We've had several recommendations from the Indiana Small Business Development Corporation, including some visually impaired clients. We've definitely seen projects come in from technologies developed by Crane. We've had recent talks with kind of retail startups, specifically in Indianapolis. So we've seen all those partnerships actually come true.
Jessica, another question for you. I know the firm that you work at, Figured Daniels, participates in the law firm pro bono challenge. Is that correct?
Yes.
Could you explain kind of what that is?
Sure. So the pro bono challenge is really kind of a call out to all the large law firms in the U.S. as a way to increase and kind of foster a pro bono culture and really address some expanding pro bono needs. And so any firms that are signatories to the pro bono challenge agree that they will provide approximately 3 to 5% of their total billable hours to pro bono work. And there's also the understanding that a majority of the attorneys at any of those firms would be the ones actually participating. So it's not just falling to a small handful of attorneys, but it's really kind of becoming a pervasive culture within that firm.
So on that point, obviously, firms with large IP practices, to the extent that people in IP want to participate in pro bono work in their own area of expertise, obviously the Patent Hub is happy for doing that, or at least the patent prosecution folks. So are there any other firms in town that participate in the pro bono challenge, you know?
Yes, locally, Barnes & Thornburg and Quarles & Brady, we know are in the pro bono challenge. And then other kind of notable firms that we've all heard of are Gunner & Block, DLA Piper, Kirkland & Ellis, Finnegan. A lot of large law firms have approached this pro bono challenge and met the needs. And then there's also,
Is there an opportunity for in-house counsel as well as the pro bono challenge is concerned?
yep, you read my mind. There's a corporate pro bono challenge that allows in-house counsel to also meet pro bono needs, as well as, I think Mont previously mentioned, a lot of companies have pro bono committees that allow their in-house counsel to be involved in pro bono work. Sometimes this is outside of IP. I know recently Fakery and Lilly actually teamed up to do Wills for Heroes, which provided wills and end of life and other healthcare documents for Indianapolis police officers, firefighters. They did this also with patients at Eskenazi. So they're, at the moment, I think some of these pro bono things on the corporate, in the corporate pro bono challenge aren't quite IP specific, but that can change.
Great. One last question until we have the official unveiling of PatentConnect for Hoosiers. Jessica, lawyers are creative folks, and they have creative ways of defining what is or is not pro bono. I know one way that is not pro bono is to have a deferred billing arrangement where you agree to provide free legal services up front, later on to have them be paid services or paid later on. Do you have any examples of how the pro bono challenge kind of defines or kind of reigns in this creativity of lawyers in this regard?
Yeah, so one of the first definitions that comes to mind for pro bono and the pro bono challenge addresses is that you're addressing people with low income. But there's also a provision that says pro bono can fall under the category of providing pro bono services to educational, religious, civic, community, and government organizations. And if you further their goal, and if they had to pay standard legal services to do that, they would have a significant depletion of their economic resources. So we, view the clinic and the patent hub as, being these government organizations that are furthering the goal of, as Norm mentioned, justice to the community and allowing people to protect their rights, which is hoping to solve kind of that chicken and egg problem.
All right. Thank you very much, Professor Janice and Jessica, and we're going to transition over here to Jason, and again, Jeff and Winkai, if you could raise your hands. Thank you very much. Jason and Jeff and Winkai have spent a substantial amount of their time over the summer, even definitely more recently than that, putting together this website, which is unlike anything we're going to see anywhere across the country, and we hope it becomes a model for the 18 sites that are out there. Previously to this launch, we had a soft launch of our web page, which essentially was some text indicating what some of the qualifications were, and two options. One was a service request form, and the other was an attorney request form, or volunteer form. And that was pretty consistent with every other hub that is out there. What Jason, Jeff, and I have come up with is, I think, really revolutionary, and we hope that it's a model for other folks out there running patent hubs. We actually have some grander plans in the future for other services that might be provided in this model. Did anybody have any questions from the panel that wasn't addressed in the slides?
Can I bring up a verbal question to two
Sure.
of them? One is, what's the liability, and two, what is the issue on a case that you don't want, that no longer works, matches not what, not a good match, what would happen?
Okay, so there's two questions. One there was, what about liability? These are clients like anybody else's clients, so you want to make sure that your rules of your engagement letter clearly spells out that they're a client of the firm, so that your malpractice coverage covers that situation to the extent you were to get sued for malpractice. But pro bono clients are like any other clients, so there is a risk there. So you'll obviously want to do your best in servicing the clients to avoid that risk. And the second question was, what if you end up in a bad match? For whatever reason, you've got a client that's over demanding, their idea is just, they don't agree with you. You did a search, you think there's nothing patentable there, and they disagree with your opinion on that. They're like any other client. As long as you're not, engaged in prosecution where under the patent office rules you can't disengage from that client, you can fire them as a client. Obviously that's something that's best avoided, but they're just like any other client. We've all had opportunities where we get crosswise with a client. Maybe the client's a little dishonest. I mean, I've I've seen that. That's a bad client. You want to run away as fast as you can, and you have the right to do that. So if you end up with a match that ends up being a bad match for whatever reason, you have the opportunity to step out of that representation like you would with any other client. Again, making sure you're following the rules that the patent office spells out as far as in prosecution, in representation and prosecution. Any other questions?
Is there any provisions for liability for retired attorneys?
The question was, are there any provisions for retired attorneys? I think in that situation, you definitely would make sure you get some sort of short-term liability coverage. And I believe the state bar has a mechanism for doing that, so you don't have to go out there and try to get coverage on your own. But I do know that the state bar has a way for solo practitioners basically to go out and get coverage to do that.
How does eligibility determine?
Eligibility is basically up to the attorney. There are some guidelines out there, and Jason touched on this a little bit. One of the metrics that's out there that seems to be fairly common in the various hubs is 300% of the poverty rate, and that's based on the number of people in your household. So in the request form, you'll fill out how many people are in your household, and we'll figure out what the poverty rate is on that, so that when the match is made, the attorney can then figure out whether or not that satisfies what their definition of pro bono is. But there are other metrics out there too. Some firms, I think the pro bono challenge is one of them, is it's 200% of the poverty rate. Another one that's out there is the micro-entity status, which is pretty high. But again, patent prosecution services are pretty darn expensive. So even though you may have a fairly substantial income, you may qualify. And it's not an all or nothing thing. You may run into a situation where a client makes enough to afford some representation or pay some fees, but not the full freight. So you could come up with some sort of discounted rate on it, and the discounted portion of it would qualify as pro bono, and you could still be receiving a portion of your rated fees. But we leave that definition up to the attorney, but we try to collect that information up front. So if you have a 200% threshold, and you only want to represent people that are 100% qualified, then we won't make that match. We won't even recommend it to you. Jason, how are we doing with that?
Keep going.
Okay. Jason, do you run that? Can you run that up here?
No, not that work.
So there are things that you do as a patent practitioner to help advise and to guide the way the patent application is written that are also very expensive. So, for example, literature searches, to get particular searches done, to get access to certain documents, can be a rather expensive thing to do. How does this work out in practice? I'm less interested in what the group has to say, what the organization has to say about it, so much as someone who's done it. How do you handle that?
So the question was, how do you handle literature and prior art searches as part of this process of figuring out whether something's patentable? We let the attorney handle that however they want. If the attorney's practice and what they're comfortable with is hiring a third-party searcher to do that sort of thing, then that's on the client. That's not an expense the patent attorney picks up. All third-party expenses are handled by the client themselves. So government filing fees are handled by the client, patent office fees are handled by the client, and prior art searches are handled by the client if you want to hire a third party to do it. If you yourself want to do it, then to me that would be a pro bono service that you're providing to the client. I know on the clinic front, when we work on a patent application, to be part of the certification program, the patent office requires you to do a prior art search before filing a non-provisional patent application. So the students do that. So what I'll do in the clinic setting is I'll assign 2 or 3 students to go out there and do a prior art search on the invention. And they do a pretty good job. They find relevant prior art that's out there, and that's a free service that the clinic provides because we know that our clients can't necessarily go out and hire a patent searcher to do that. But if that's not your practice, if you're more comfortable hiring a searcher to do that, then that's on the client. That's part of the expense they have. There shouldn't be a client situation where you're having any out-of-pocket expenses related to third parties. Any other questions out there? Jason, how are we doing?
We had started up, and I'm just waiting for the rest of it, so if you got 5 minutes worth of questions, that'd be ideal.
Any other questions out there?
Yeah, so you said you scope out the engagement after the match is made. Okay, the scope of the engagement is a provisional application or non-provisional application for that matter. The prosecution, the life of that case is going to be years. So if you scope it for only preparation of the application, then you set, does it go back to the client? Now they're going to receive the correspondence, or can it then be handed over to the clinic to help, monitor that correspondence, those due dates and deadlines? Because it's really easy for a client to lose track of that 1 year date, or for 3 months ahead of time to give more information to the developer and mention and need to expand their application. Because in private practice, I might not have a rocket ship client today, but I might in 6 months, and so it would be great to take the wrong client off the list after the project's done, but also engage them to get lost in the shuffle.
Yeah, so the question was, what do you do in a situation where you have fairly limited scope of engagement? Maybe it's just to file a provisional patent application. Then you step out of the process. Kind of what happens to these clients? Does that come back to the clinic, or is that on the client themselves? And the answer is it's back on the client themselves. You have totally stepped out of the situation. And obviously, you'd want to make that clear to the client, that it is on the client to make sure that they monitor their mail and that they look for due dates and that you've got this 1 year due date. And it would behoove you to put it in your engagement letter or your last correspondence with them, that it is very important that they know about that 1 year date, but it is not your responsibility as the attorney to handle that. In the clinic setting, Jessica kind of alluded to it earlier, our philosophy is that once we take an engagement on the client, whether you filing a provisional, a non-provisional, or the PCT, we're going to kind of follow them through the whole process because we've made a commitment to them. That's not to say that we can't step out, because we could. We're just like any other law firm, we can do that whenever we want, again, given the patent office's rules. But our default right now is that if we have to file a PCT application for you, and you get to that 30 or 31-month date, and you decide to start foreign filing, the clinic's going to step out of the equation, because in our opinion, if you can afford to pay foreign filing fees, you can afford to pay a U.S. attorney to help you with it. I see another hand.
I had a quick question about litigation. My husband and I have a firm, so it's just a two-lawyer firm, and we've had several clients in the past who have approached us, and we've assisted them in some of these copyright trolling lawsuits filed by Malibu Media. And a couple of these clients didn't have any money really to defend themselves, but they actually had very defensible positions. So we stepped in to kind of, help negotiate quick settlements. But, in some of these situations, it would have been nice to be able to refer them somewhere so that they could, stand their ground, but they didn't have the money to stand their ground. And is the IP clinic a place that we could refer people like that to, or is that maybe a little more than what folks get into?
Yeah, the question was, as you run into some situations where there's litigation involved, and it becomes a fairly taxing event to, see it through or to kind of stand your ground, and the opportunity to present yourself to kind of help these people reach an agreement. But it was less an ideal situation just because the people couldn't afford to stand their ground. And whether or not that's the type of situation the clinic can help. I think it is. I am not a litigator, so that's not my skill set, but I do have enough connections in the IP community where I can pull in adjuncts to help with those sorts of things. And I've had people volunteer in that regard, so if there was a litigation-like matter, that they could kind of step in as an adjunct professor with the clinic, and it would be a joint representation currently conceived between the clinic and whatever firm that attorney happens to work for. But I think that's an excellent opportunity, and that, to the extent you've got people that are kind of, how did you put it, Crystal? You don't refer them as the T word?
I would call them abusive patent litigation techniques.
Abusive, and I'm going to call them IP litigation tactic folks, but it would be a way to kind of counteract that, and maybe even quash it. If they know that anytime somebody comes in and they do something like that, they're going to be facing an IP clinic that's providing IP free legal services. Well, maybe the business model implodes, and that sort of activity goes away. So, all right, with that, Jason, take it away.
So thank you all for your questions. Apologies, it's never a good idea to start off a talk by dropping your computer on the ground. So if anybody's headed to the Apple store after this, I can use a lift. Sorry I left my black turtleneck at home, but I'm going to give you the sort of tech side of things today. In a previous life, I used to work in computers before I became a patent attorney. So that's how, if you're wondering how I got roped into this, that's my involvement. So I'm part of the center. So I'll keep this quick as well. So today I'm going to give you just the attorney's perspective on how to interact with PatentConnect, which is the website we've built. We're going to talk about registration very quickly. We'll talk about how to actually connect to a client, and then we'll talk about the final phase, actually providing assistance to them. Registration is extremely easy. You can do it at any time, from any device. If you find this talk boring, I will not be offended if you about your mobile phone and start registering right now. It'll be a good thing. So you can register right now. It's very, very easy. We've even provided links on the page where you can look up information that you might not have. So we ask for things like your attorney number, your reg number, these sorts of things. There are links right on the page for you in order to look up that information. I know I don't know mine off the top of my head. I'm sure you guys don't either. And so the website's smart enough to open up a different browser tab, and so that you can just search for it very quickly and easily and not lose your place within the registration. Very quick, very, very simple. Once you get done, you'll be forwarded to a status page. Now, initially, your access is sort of restricted within the PatentConnect website, and that time is necessary for Casey and for Norm to make sure that all the information, of course, is accurate and that you're in good standing. Once everything's been approved, you'll notice that we have a little quick look panel up here in the corner. And here it tells you, of course, whether or not you've been approved into the system. It'll tell you kind of pending connections, and there's other information that gets displayed there as well. In addition, your future clients' information, as you start to accept people through the system, will appear down at the bottom of the page. So if you can't remember their phone number or their email address or all that sort of stuff, it's all right on your home page when you log in. Once you've registered and been approved through the system, then you can connect through clients in two different ways, through our matching program first and through the marketplace program as well. Now, the matching program is sort of more traditional of the two. And this is where the clinic actually reviews the invention and the inventor's information, and then they attempt to match them to an attorney. But the two programs actually work together, and I'll explain how they do that once I describe how the matching program itself operates. In order to qualify for the matching program, the inventor must have taken the USPTO's training module. This is free, it's online, it's about a 45-minute video where they require them to not only watch the video but answer some questions. This is intended, of course, to improve their knowledge and improve your experience with them as well. Next, necessitate that they haven't filed more than 4 patents. You'll recognize this, of course, from the microentity status requirement. We also have an income threshold that's tied to the microentity status figures. We require that they be a Hoosier. Because of our Bloomington ties, of course, we require that their favorite film is Breaking Away. No, I'm just kidding. We'll accept Hoosiers. Sorry, Golden Domers, if you're in the room, Rudy is not acceptable answer. No, I'm just kidding. So if they're from Indiana, they're okay though. And then we've got a couple of other timing requirements. These are, we would necessitate essentially that they provide us with at least 2 months of time before they want to file a non-provisional application. And if we're dealing with an inventor that needs some help on an office action, we also require at least a 2-month window for that as well. The reasoning here is just we need time to find them a good match, and you need time to help them, right? Now, under the matching program, once the inventor meets those requirements, then Norm and Casey will do their best to find a match for them. This is based on practice area, on timing, on conflicts, and on a whole host of other things. The website takes care of all of that, a lot of it for them. So from your perspective, however, as a registered attorney with PatentConnect, you don't have to do anything. And I want to stress this. The website and the clinic do all of this work for you. So all of those requirements that I just went through very quickly, all of that is done and screened automatically for you. Once they've found a good match for you, you'll then get an email message with the inventor's information, and that inventor will then appear on what we call your Connect page. Now, the Connect page essentially acts like a holding grounds for the inventor to help give you enough time to do a conflicts check or to simply decide whether or not you have the available time in order to help them. But that decision, I should stress, is entirely up to you. If If you do nothing, after 5 days, this inventor will get returned back into the marketplace or into the matching program, whichever one they're a part of. So do nothing, don't worry about it, they'll go right back into either system they were a part of. If you say yes, then of course they'll become your client. You form that attorney-client relationship. If you say no, of course, they'll go right back into the system automatically. So it's very, very easy to use. I don't know if I would trust this guy, but it's a very, very easy to use system. Now the other way that you can connect to an inventor is through our marketplace. And once you've been approved in the system, you can access it without our intervention. So there's no need to actually wait for us or wait for the clinic or the people in it to actually help you find an inventor. You do this entirely on your own. So if you have some free time and you'd like to help out, you can always just log in and take a quick look at the marketplace. It's very easy to do. We place all of the information right at your fingertips as well. Here you can click the different tabs, so the description, background, inventor, and different notes that the admin might have put in there for you. You'll see all of the different information about the invention. The marketplace also automatically sorts these inventions. So at the moment, the marketplace is empty. We just launched the website about an hour ago before this started. But it automatically has a series of different algorithms that look at things like your practice area, how long this person's been in the system, all these sorts of different factors, and it displays them in a way that they think merit your attention. So the first person on the top should, in theory, be the best fit for you, assuming the inventor has filled out their information correctly. So all of that work is done for you. And all of the information that we talked about, those requirements, again, are right there in the system for you. Now, unlike the matching program, the marketplace is far less restrictive about its requirements. The only thing that we require is that the inventor actually has taken the USPTO's training module. So what this means is that some of the inventors may not actually qualify for pro bono services underneath your firm's guidelines. So to help you make that determination, we've also built that information right into the marketplace itself. All you need to do is select the Inventors tab from the listing I showed you before in order to determine whether or not they meet your firm's guidelines. Now, because the marketplace's requirements are lower than the matching program, the marketplace may contain inventors that actually qualify for both of these, so both the marketplace or the matching programs themselves. So in essence, the marketplace itself sort of acts as a holding grounds, if you will, where the inventor can sit while they're waiting the admin to match them with an attorney. So we're just trying to find people connections as quickly as possible. That way, if another attorney like yourself, if you have some free time, you can log into the marketplace to help whoever you'd like, and most importantly, whenever you'd like. So if you've got free time, it's there and it's available. This also allows us to make sure that the matching program inventors are getting help as quickly as possible. And we think we've made it very easy to read as well. So you'll notice here that the program qualification thing, the header here will turn green if they qualify for both of them, the matching program and the marketplace programs. You also see a series of different check marks next to it if they meet those requirements. For those of you who are at firms that use the 200 to 300% thresholds, we have those for you there right up above. If you click the little eyes here, you'll also see the information pop up on your screen. This will work on a mobile device, on a desktop, on whatever. And you can actually read a little bit about the income threshold or read a little bit about the timing requirements. So all the information is right there. You don't have to remember any of it. We've tried to make this as easy as possible. So after poking around the marketplace, if you decide that you might want to take the inventor on as a client, then all you need to do is just click the Connect button right up in the corner there. And they'll be pulled from the marketplace and placed onto your Connect page, where you'll have, again, another 5 days to decide whether or not you want to represent them as a client. So you have that period of time where somebody else won't pull them off the marketplace, so there's no confusion. They're in that little exclusive bubble for you. So now that you've registered and connected with an inventor, it's up to you to assist them. And as Nora mentioned here, the scope of your representation is entirely up to you. For all intents and purposes, that's where PatentConnect sort of walks away. Our job is done here. But we have built some tools into the website that you can use for that as well. So on the status page, as I said before, when you log in, you'll see all your client's information. That information is dynamic. So if the client updates their phone number or something, say a year from now, and you want to give them a call, it should be in the system and should be updated accurately for you, assuming you're keeping that up to date. We've also built a note-taking function into it. So if the admin wants to leave you a note or you want to take notes in it, the system will actually automatically place those in the systems for you as well. So if you're on a phone or whatever, you can put whatever you want in there. That information is kept private, so it's not shared with the inventor. Only you yourself and the admin can see that information. So So that's it. We've tried to keep this process as simple as possible. And as you can guess, a lot of work went into this project. I'd like to recognize again, we've said it a few times here, but Jeff and Wenkai, research assistants at the center, they've done an absolutely fantastic job for us in other projects as well as this one. So it's much appreciated. I would encourage you guys to visit the other patent hubs as well. I can say, I think unequivocally, that we've built the most sophisticated platform in the country. So I'm very hopeful that you guys will now start to use it. But it's now open and available. If you have time to register today, we'll hopefully be getting some inventors with this as soon as possible.
All right, we've already had you guys over time. Anybody have any quick questions for Jason on the patent hunt? Jim?
Norm, how do you protect confidentiality with disclosures?
The confidentiality, there's a confidentiality requirement on there, so when an attorney signs up for the system, they're reading confidential, just like any sort of pre-client consultation.
What about within the law school, people that have access?
Oh, it would only be the students in the clinic themselves who are underneath the rule of professional responsibility. Not, it would be the Another question?
Similar question. Subject matter conflicts were real tough to navigate. They just, they jump on you. So when you send out this inventor information where you're doing a match, or if you even in the marketplace and there's enough information to get an idea about whether or not you want to take the engagement, how do you navigate that? Can you get this stuff in the stage? When we get elevator trade, first thing I tell these people when they get on the phone, don't tell me anything until I ask you a question, right? Because I want to meter it in, in a way that it can help me identify subject matter conflict. Here, it's going to kind of spring on you.
That's an interesting question. I anticipate one way we could handle that is that the hub itself would try to distill this down and say, hey, this relates to a brake system. So hopefully that's enough for you to do a conflicts check and, we represent brake customs, so that's a conflict, some kind of conflict, we're not going to handle that. Any other questions? All right, thank you all for sticking around for a couple of minutes.